we are hoping you leave here with a better understanding of Passport to Support dollars, tips and resources to assist you in making informed choices, a clearer understanding of the application processes, as well as information about the range of supports and services provided by local agencies. Tonight we have guests here, Brendan Pooran, who's sitting right here. Brendan is a lawyer from Pooran Law, and he'll share information regarding responsibilities when hiring support personnel.
Okay, well, good evening, everyone. Brief agenda, so I'm going to give you a sort of a high-level overview of employment law, so Employment Law 101. And then we'll talk about the difference between an employer and an independent contractor, followed by employee rights and employer obligations, and finally we'll chat a little bit about implications if you are entering into an independent contractor relationship with your worker. So, very briefly, when it comes to employment law, we're looking at three different aspects. The first is the legislation itself, which is called the Employment Standards Act. The second is a contract that you may have in place with the worker, and that may be an employment agreement or an independent contractor agreement, depending on which way you decide to go. And thirdly, there's something called the common law, which is judge-made law, decisions that are issued by the courts. In all circumstances, the Employment Standards Act, and I'm going to refer to it as the ESA, trumps anything in a contract, and a contract can trump the common law. So what this essentially means is that, the ESA provides minimum standards for all sorts of aspects related to employment. Everything from the minimum wage to overtime to hours of work to vacation leave. And you as an employer cannot contract out of those minimum obligations. Okay, so if the minimum wage here in Ontario is $11, you can't pay somebody $8 an hour to work. You can, however, obviously, pay more money, so you can enhance the employee's rights. You just can't contract out of these minimum requirements. The other important point on this slide is that there is a complaint process available for a breach. So you have to be aware that if you are entering into this employment world and you're employing workers, if things go offside, there are a number of different avenues that worker can take. One of those is filing a complaint under the Employment Standards Act. Okay. Secondly, we always recommend that you have a contract in place, and this contract will look a little bit different if you're treating the worker as an employee or if you're treating the worker as an independent contractor. And we're going to get into the differences and the subtleties in a few minutes. But the terms agreed that are not covered by or exceed ESA requirements are included in this contract. You want to make sure that you enter into one of these contracts or that the worker signs off on it before they actually start working. Okay. Otherwise, arguably, the contract could be deemed sort of null and void and unenforceable. It usually includes a probationary period. So under the ESA, the typical probationary period is 3 months. You can add to the probationary period, and you would do so in the agreement. Hours of work, so how many hours of work per week and when is that work taking place? Obviously wages, vacation entitlement. So with vacation, you could either give vacation time or you can pay vacation pay, and termination provisions, which is very important, and I'll speak about that in a few minutes. And finally, just to complicate things even more, we've got this area of law called the common law, and again, these are judge-made decisions. These are decisions that are issued by the courts, and where this comes into play is usually when an employee is terminated. okay, is when the employment relationship is coming to an end. If the employment relationship is coming to an end, you can either terminate an employee with cause or without cause. In the majority of cases, the employment relationship may come to an end without cause. And if you end employment without cause, you are required to either provide the employee with a reasonable amount of notice or a reasonable amount of pay in lieu of notice. The ESA stipulates the minimum amount that is required to be given or required to be paid. So if the employee is working for less than 3 months, then there is no requirement. Between 3 months and 6 months, you've got 1 week. Between 6 months, that was 3 months and 6 months, yeah. And then between 6 and 24 months, you've got 2 weeks. And then it goes up 1 week per year of service up to a maximum of 8 weeks. Okay, so that's what the ESA says. But just to complicate things, you've got the common law, and the courts have said something different. Okay, so the courts say no, you actually have to pay between 3 and 6 weeks per year of service, depending on the circumstances. Okay, where they consider the person's age, the position, the salary, the availability of other employment out there. Okay, so very important for you to sort of have a general grasp of this before you enter into any kind of employment relationship with a worker. So the question that we find families face most is whether or not the engagement, the relationship that they have with their worker is based on an employer-employee relationship or that of an independent contractor. The majority of families that we meet who have had workers in place for a number of years assume that there's an independent contractor relationship there. Sometimes there is, many times there is, but unfortunately sometimes when we start asking questions, a few more questions, and digging a bit, it's evident that based on the particular characteristics of, a number of characteristics, which I'm going to get to in just a second, it's more of an employer and employee relationship. And therefore, there are additional responsibilities and implications placed on the family. Okay, and this is regardless of whether you've got a piece of paper that identifies, the fact that the person's a contractor. Okay. In terms of deciding whether or not an worker is an employee or an independent contractor, it's going to depend on the forum. Okay, we've got a few different forums here. We've got the common law. So what does the common law say? We've got the Canada Revenue Agency, which may or may not come to a different conclusion. CRA is concerned with ensuring that they are receiving payroll remittances, EI remittances, CPP remittances, etc., the Employment Standards Act, and WSIB. So hopefully, if things are structured properly, somebody would either be an employee or an independent contractor under all four of these different heads. But we're seeing more and more cases come up these days where the ESA may say, you know what, this person is an employee, but then CRA is saying something different in that the person is an independent contractor. And I'm going to go through, a couple of the factors that lead these different forums to their conclusion. In terms of the factors in the legal test, we've sort of identified four main factors here. The first one, which I'd argue is probably the most significant, is control. How much control does the family have over when the worker is working, when the employer is working, how many other families or how many other clients the worker can have? Okay, the more control, the family has over the worker, the more likely it would be that the worker is an employee. Okay, the less control, we swing the other way to an independent contractor. An opportunity for profit and risk of loss. So in other words, can the independent contractor work for multiple families? Can the independent contractor say, I'm available on a Thursday between 4 and 6, and I've got 4 or 6 respite spots available, and make that available to individuals and families. If there is that opportunity for profit and risk of loss, then we swing more towards an independent contractor. If not, we go the other way to the employee. Functional integration. So, really here what we're trying to say is the person treated as an employee, or like, other employees that you may be employing? It goes without saying that, if they're provided with, let's say, a vehicle, or they're provided with resources required to support the individual, they may be considered an employee versus an independent contractor. And then dependency. How dependent is the worker on the family for their livelihood? So if the individual is working 40 hours a week, is getting paid $15 or $16 an hour, isn't working for anybody else, then chances are that individual is very, very dependent on the family for their livelihood, to pay their bills and to make ends meet. If that's the case, the worker would be, likely an employee over that of an independent contractor. So sort of drilling down a little bit more and looking at family-specific factors in order to determine whether or not we're talking about an employee or an independent contractor. The duration of the relationship, so how long has the worker known the family? What is the intention of the parties? And that's where we typically start. Is the intention... have the parties come together with the intent that there is this independent contracting relationship, or is the intent that the person be treated as an employee? And this kind of goes without saying. It's quite logical, but you want to ensure that both parties' expectations are consistent with each other. You want to ensure that if you are treating somebody, or you're intending to treat somebody as an independent contractor, that they understand that. Because there are all sorts of responsibilities that come with being an independent contractor versus an employee, and we'll talk about those in a few minutes. We've seen it happen in a number of cases where family thinks that they've got an independent contracting agreement in place, and therefore that's the nature of the relationship. But as soon as the engagement ends, the employer is applying for the employee is applying for EI. Okay, because maybe they always thought that EI premiums were being deducted, and that they were being treated as an employee. We talked about control over how, when, where, and by whom the services are provided. And then we look at direction, supervisions, and training by the family. So how much supervision and direction is the family providing when the worker is supporting the individual? Dependency we spoke about. Exclusivity we spoke a bit about. So if the worker is sort of exclusive to the family and that's their primary means of income, then again that would lead more towards the employee side of things. And flexibility. Are the ships fixed or flexible? Flexible, more toward independent contractor. Fixed, then arguably more toward an employee. Keep in mind as I go through these factors, nothing is definitive. There's no definition of who would be deemed an independent contractor versus an employee. You've got to look at all of these factors in their totality in order to come up with the appropriate designation. So let's say that the intent is that the worker be treated as an independent contractor, okay? first and foremost, you want to ensure that you have an independent contractor agreement in place. Okay, so agreement between the family and between the worker, stipulating that the worker is, it's intended that the worker be treated as an independent contractor, and a number of other terms to protect you as the family from any exposure to, or minimizing your exposure to risk. So if we're talking about an independent contractor status, then you as the family do not have to deduct income tax, CPP, or EI deductions. Okay, that's the responsibility of the worker, of the independent contractor, and you want a term in that agreement stipulating that no deductions are going to be taken off of the paycheck, and that it is the worker's responsibility to remit these payments to the CRA on their own, and that if they don't, and there's any kind of future liability, that worker indemnifies you or protects you, the family member, from having to make any kind of payments to CRA in the future. There's no restrictions or obligations as to paid holidays, vacations, hours of work, or overtime. Okay, so all of these are governed by way of the independent contractor agreement. Versus if the worker was an employee, then the ESA takes over, the Employment Standards Act takes over, and the Employment Standards Act dictates that you have to pay individuals for paid holidays, or that after 44 hours of work in any given week, you've got to pay time and a half, etc. No employment law reasonable notice of termination requirements. Okay, so remember I spoke about the employment relationship or the contractor relationship coming to an end. There is no requirement that you provide reasonable notice if the person's an independent contractor. That again should be stipulated in the independent contractor agreement. WSIB and insurance requirements, you want to make sure that the worker has their own either WSIB in place or alternate insurance coverage in place, and that they provide you with proof of insurance. Okay? Again, in order to limit your liability. And that they've gone through any kind of Occupational Health and Safety Act training, and that they're sort of aware of the Human Rights Code and how that all works. So recommendations, and I've gone through a few of them already, clearly set out intentions, and we've emphasized that quite a bit. Include the indemnity to cover deemed employment. So again, this is a way of protecting yourselves. So you're essentially saying, if for whatever reason, any of those various forms that I identified, the Ministry of Labor or Canada Revenue or WSAB, for whatever reason, despite this independent contractor agreement that we have in place, deems you to be an employee, you, the worker, are covering whatever financial obligations result as a result. Specify fixed term or purpose, so how long is the agreement to be in place for? Include fee for service arrangements, so in other words, ensure, make sure that you're just not cutting a check every 2 weeks for the same amount, the same number of hours worked. What you need to have the independent contractor invoice you, okay, and then you're issuing a check based on that invoice. Specify the right to work for others and/or employ subcontractors. So in other words, ensure that you're not requiring that the independent contractor work for you exclusively. If you do that, the whole, arguably the whole independent contractor arrangement could be blown away. You want to give the independent contractor the right to work for other people, and confirm qualifications and compliance with training, licensing, and regulatory requirements. And this is very, very important, that you ensure that you know what the qualifications are of the individuals that you are hiring, and that you ask for proof of those qualifications as well. That you go through the proper background checks and ensure that you have a good sense as to who this individual is before contracting with them. A few more recommendations: specify responsibilities. So clearly set out what the responsibilities of the contractor are. Include terms on which the agreement can be terminated. So typically we'll see, a provision that says the agreement is terminated immediately in, each of these specific cases. Okay, or if the if those cases don't apply, that a reasonable amount of notice is either provided by the contractor or by the family if the relationship's coming to an end. We talked about WSIB certification or insurance coverage, the vulnerable sector screening condition. Confirm your own insurance coverage. This is very important. So if you're employing people in your home, or if the worker's taking the individual out, give your insurance provider a call. Let them know, and ensure that if additional insurance coverage needs to be taken out, that it is, or if additional insurance coverage does not need to be taken out, try to get the insurance company to confirm that with you in writing. And it goes without saying that you want to follow the terms of the agreement that in practice that you have papered, that you have agreed to with the contractor. Okay. Moving to responsibilities, excuse me, that you would have as an employer. Okay, so if the intent is that you're entering into this employment relationship where you're an employer and you're hiring a worker as an employee, you as the employer, you have to deduct and remit income tax, premiums for Canada Pension Plan, and premiums for EI as well. And remember that as an employer, you also have a responsibility to provide a subsidy to CPP and EI premiums. In other words, you're paying for some of those premiums. So you want to factor that into the overall sort of compensation package that you're providing to the employee to ensure that that everything balances out. You must provide paid holidays, vacations, comply with hours of work, and overtime requirements. So this goes back to all of the requirements that are in the ESA. If you want to enhance any of these requirements and provide a greater right or benefit, let's say to the employee, then that should be stipulated in the employment agreement. And that's actually where I should have started. Just as it is important to have an independent contractor agreement in place when the worker's an independent contractor, if you're hiring a worker, make sure that you have an employment agreement in place stipulating all of these terms. You must provide reasonable notice of termination, and I've gone through that already. You want to look into purchasing WSIB or alternate insurance coverage. Okay, so again, call up your insurance provider and find out what your options are. You have to meet requirements of the Occupational Health and Safety Act, and you also obviously have to meet requirements dictated by the Human Rights Code. Recommendations for employment relationships. So screen your candidates. So again, very important. Confirm the qualifications. Confirm their qualifications. Know who you are employing. Speak with references. So it's often advisable to ask the employee for references for other families or individuals that they've worked with. Phone those references before providing the worker with any kind of employment agreement, and specify that vulnerable sector screening will be a condition of employment. I think that goes without saying in terms of the importance. Again, have a written contract in place. Sign the contract in advance of the start date, and I've sort of emphasized the importance of that. Make the contract conditional on screening and include a probationary period. So again, with respect to the ESA, The probationary period is 3 months, but you have the flexibility to sort of increase that. In terms of a termination clause, as the employer, as the family employer, remember that the ESA sets out the minimums and then the courts sort of add to that. What you want to do is include a term in your employment agreement that limits your obligation to provide notice or pay in lieu of notice to the requirements specified in the ESA, to the minimum requirements. Okay? So you're looking at, a week per year of service versus, 3 to 6 weeks per year of service, which can obviously add up. Specify the vacation entitlements. So are you giving the worker time off, or are you making vacation pay payments? In terms of pay, are you paying the worker hourly, or is the worker going to be salaried? Overtime, when and how is it compensated? So you can compensate in the form of lieu time, or you can compensate in the form of pay. The Employment Standards Act says that if anyone works more than 44 hours in a given week, that they're entitled to time and a half. Not everybody, I should say, that they carve out exclusions for lucky people like lawyers. But for the workers that you're hiring, once that individual works more than 44 hours, then they're entitled to time and a half. And specify hours of work if work is going to be greater than 8 hours per day or 40 hours per week. Okay, so you want to make that clear in the employment agreements. In practice, so recommendations for good and healthy employment relationships: check in regularly. Okay, make sure that, again, everyone's expectations are consistent and that the worker doesn't have any concerns with the way things are going. Provide regular evaluations quarterly, I think, would be a good idea. Progressive discipline for misconduct. So if there are issues that arise, make sure that you address them, that you speak to the employee about them, and that you paper that conversation. If the employee has been consistently late, let's say, over the course of a 6 or 7 month period, and in month 8 you decide to terminate with cause as a result of lateness, that's not going to be looked on very positively, because he never provided the employee with any kind of feedback or opportunity to improve. Be consistent and clear with expectations. Provide communications in writing, we spoke about that, and keep track of overtime work and time off used. So very, very important. We've seen lawsuits arise, 4 or 5 years later, alleging that the worker, worked 50 hours a week or 55 hours a week going back to year one, and the family is all of a sudden being asked for this massive amount of overtime pay. It's important for you to keep track of hours work. General recommendations, obviously you don't want to have to run out to a lawyer every time you go to hire an individual, but I would recommend, if there are resources there, that people have brief consultations before hiring employees, generally, just to set up their either their employment agreements or their independent contractor agreements, and you sort of make sure that all the requisite terms and conditions are in there as they relate to what things are going to look like in practice. And if you're coming to the end of an employment relationship or a contracting relationship, before you pull the plug, if you're unsure about anything, about whether or not you should go with cause or without cause, or how much you need to pay, or what potential liabilities may arise, it's often a lot more cost effective to seek a brief consultation before you do that, rather than being on the hook for added liability later on. Okay. So that's what I have tonight. Any questions at all? Yeah. So the question is, what happens? So in this particular instance, the worker ended the relationship but didn't provide reasonable notice when doing so. Unfortunately, even though there was a contract, it's one of those situations where it may cost you more to sort of fight it than to just let it go. Arguably, if there were any outstanding monies owing to her, okay, you could have maybe withheld, but yeah, it's just one of those unfortunate situations. So if you needed to be driven around, can you pay? Can you sort of pay for their driver's training course and that sort of thing? So I think there are two different aspects of that question. One is, can you maybe use passport dollars for it? And I would defer to Heather, but I think she's gone. So if there's anyone else from the passport agency here that could answer that part of the question, in terms of you as an employer, absolutely, that could be a benefit that you provide to your worker, but you would want to clearly set that out in the agreement that you have with him or with her. Question is, can you use passport funding to pay for a support worker's driver's training course? So the answer is it's something that would be considered, and they just, you'd want to sort of outline the goals and the reasoning behind the request. Okay. Is there anywhere that you can find sort of templates for independent contractor agreements and employment agreements? Or some agencies, I've seen some agencies provide templates, and there's talk of a number of agencies sort of working on that, which I think is a good idea, but you do want to be careful in that, you do understand what needs to be tweaked and in what circumstances, things should be tweaked. I think there are a lot of sort of independent contractor agreements out there online, not that I'd necessarily endorse them, but independent contractor agreements seem to be easier to find than employment agreements. But I would check maybe with your local agency to see if they have anything in place. So the question is, what if your workers don't want to pay taxes? I would find another worker, quite honestly. Yeah, I mean, well, I'll take a step back. You'd want to try to ensure that the relationship is reflective of that, of an independent contractor. So you would want to set things up in any way you can to support the case that this person's an independent contractor. If the person's an independent contractor, then you have an independent contractor agreement in place saying, you're an independent contractor. We, the family, we're not required to deduct and remit anything to CRA. That's your responsibility. If you don't do it and CRA comes after you, you agree to indemnify us. Now, an indemnification isn't worth the paper it's written on if the worker doesn't have any money to indemnify you. So you want to be very, very careful. Now, if you think that the relationship is such that you are an employer and they are an employee, then you are obligated to deduct and remit. There are no questions asked. I mean, if you don't do that, you're really exposing yourself to significant risk. The question is, in an independent contractor situation, is it possible for them to sub to someone else? The answer is yes, but that's a term that you want to address in the agreement. So if you want to ensure that they are not able to do that, you should lock that down in the agreement. What would be involved in setting yourself up as an employer? Well, in terms of payroll or generally, or you need to set up a payroll account for sure, because when you are deducting and you're making these remittances, you want to ensure that they are being allocated accordingly. You want to ensure that you're sort of up to speed on, not on the every aspect of the legislation, but on your sort of general responsibilities as an employer. You want to ensure that you've got an employment agreement in place as well. So the question is, would you not address all of these income tax deduction and remittance issues in your agreement? You absolutely would. Well, you absolutely would, but it only works if they're an independent contractor. If they're an employee, you as the employer, have to make those deductions and remittances. So the questions around HST and are there certain designations that are exempt from HST? What I would say is that if you are, so if you're, and I'll bring this back to, hiring workers. So if you are hiring an employee, you're obviously not paying HST on their wages. If you are hiring an independent contractor, then it's up to the independent contractor as to whether or not they're going to be charging you HST. Generally speaking, if they're earning more than $30,000 a year, they have to charge HST. Yeah, so the comment there was if you're contracting out or paying engaging in a fee for service arrangement with a not-for-profit organization, you may not have to pay HST. I mean, you'd really look to the organization to provide you with guidance in terms of whether or not they are charging HST for their services. But in terms of you as the employer contracting with a worker, the obligation is on the worker to tell you whether or not you should be paying HST on their invoices. Absolutely, and a great point. So if they are charging you an extra 13%, make sure that there is a registered HST number at the bottom of the invoice, and that you're just not paying them a 13% bonus each week. Yeah. Why would somebody choose to be an independent contractor over an employee? So as a worker, from a worker standpoint? From a parent standpoint, well, it arguably, if it could limit your exposure quite a bit and your work. So, you don't have to deduct and remit to CRA every month. You don't have to necessarily be, intimately acquainted with all of these different requirements under the Employment Standards Act. You don't have to pay for holidays. You don't have to pay for overtime. You don't have to pay. You're not subjected to the notice provisions in the Employment Standards Act as well. So the question is, I'm assuming the independent contractor is the way to go. I'm hesitant to say yes or no. It's a lawyer's favorite answer. It really depends. Like it really does. So it depends on the nature of the relationship. If everything was even and you had the choice of going independent contractor versus employee, I would say that in the majority of cases people would want to go in the independent contractor route, and they're often advised to go the independent contractor route. But you have to make sure that the factors and the characteristics of the working relationship is reflective of there being an independent contracting relationship there. The independent contractor hurt themselves. So I'm not going to suggest that I know all about the insurance coverages out there. What I would suggest, though, is that you absolutely check with your insurance provider to ensure that your policy would cover those types of situations. With your home insurance policy, typically there's a liability piece associated with your policies. So depending on how much you're covered for, that homeowner's policy may be sufficient, but you definitely want to check with your provider. You also want to ensure that the contractor has their own liability insurance in place, or WSIB in place for any unforeseen circumstances that come up. So he doesn't work. So the question is, your son's in a nursing home. It's your brother, and are you contracting with the independent contractor? You want to contract with the independent contractor. And your brother wouldn't be considered a dependent of yours, I guess, no. So, I mean, yeah, you'd have to look into that. In that case, you wouldn't want to hire any worker that doesn't have their own insurance in place. You may still want to give your insurance provider a call and explain the situation to them and see if there are any other policies that you're able to, or riders that you could add on to your existing policy.
Thank you, Brendan, for sharing information this evening on hiring a support worker. Great questions from the audience.